The buyer breached the contract. Who gets the earnest money? That's the age-old question. I'm Ben Weaver, Illinois attorney. I help folks all over the Chicagoland area buy and sell houses, and I also help them with wills and trusts and other estate planning documents. And today, we're going to talk about the return of earnest money. Here's the deal. Earnest money is a deposit that the buyer puts down when they first enter into a contract with the seller to purchase a house. The parties negotiate that amount, and it varies all over the place. Sometimes it's as high as 5% of the purchase price. Other times it's as low as just $1,000 just to get things moving and rolling right along. Whatever that amount is, the parties agree to the amount, mutually agree to that amount, and then the buyer has to deposit the amount with the escrowee, which can be one of the real estate brokerages, it can be the title company, sometimes even an attorney will hold on to it for the buyer. Within the contract, there are a number of contingencies that the contract can be canceled and the earnest money will go back to the buyers. And I'm only talking about the contract in the Chicagoland area, the multi-board residential real estate contract. Even in the city of Chicago, there's a different contract, and you go anywhere else, even outside of Chicago, you go to Rockford or Peoria, it's a different contract. But within that contract, after the seller signed it, there's a 5 business day attorney review and inspection time period. Now, within those 5 business days, the buyer has a chance to review the contract with their attorney. If the parties agree to a home inspection, the buyer has a chance to inspect the house. And if something goes wrong within those first 5 business days and the buyer says, I made a horrible mistake, I just want to cancel the contract, the buyer has the right to cancel the contract for any reason other than just the purchase price of the house, and the earnest money will go back to the buyer. Oh, there are other contingencies in the contract. Say there's a finance contingency, so if the buyer needs to get a loan to buy the house, there's an opportunity up to a certain date before the closing, where if it just isn't going to work out with this loan, the buyer has the opportunity to cancel and the earnest money will go back to the buyer. If there is an HOA with the house, there's a contingency in there where the buyer has a chance to review the HOA docs, and if there's a major issue with the HOA, say there's a special assessment coming up that the buyer wasn't aware of, they have a chance to cancel the contract and the earnest money goes back to the buyer. If there are any major insurance issues that the buyer wasn't aware of and it's going to lead to an increased insurance premium for the buyer after the sale, the buyer has a chance to cancel the contract and get the earnest money back. I hope you're getting the way this is rolling here. There are a lot of opportunities within the contract for the buyer to cancel and get the earnest money back. It's very rare that the contract is canceled without some sort of justification with a contingency where the buyer, in fact, doesn't get the earnest money back. There are some possibilities. Maybe we get to the day before closing and everything is completed and the loan is ready and the buyer just gets cold feet and says, I just can't buy this house. There may be a chance for the seller to get the earnest money in that situation. But for the most part, if the contract is canceled, it's usually due to a contingency in the contract and the buyer gets the earnest money back, unfortunately. As a seller, that's very frustrating, but sometimes it's best just to move on by this buyer who just, for whatever reason, can't get together and find a buyer who can buy the house. Because if you don't agree to release the earnest money to the buyer, if you want to fight, you want to go to court, all that's going to do is just delay the closing. It's going to delay you finding a new buyer who actually has the ability to buy the house, and you're stuck arguing with a bum buyer who can't do it versus going out and finding a good buyer who can. So, unfortunately, the way the contract is written, almost always the earnest money goes back to the buyer. Every once in a while there will be an exception, but the buyer does have the upper hand in receiving the earnest money if the contract is canceled. Do you have any situations, any stories about either receiving the earnest money deposit or not receiving the earnest money deposit after a contract is canceled? Leave it in the comments below. I'm Ben Weaver, Illinois attorney, and I'll see you in the next video.